Okay, good afternoon, Mr. Jordan.
Good afternoon, Judge Lowe.
All right, what's our reset date for this calendar?
January the 19th.
All right. Thank you. Okay, it's 2 p.m. Good afternoon, ladies and gentlemen. My name is Judge Lowe, and we are going to begin with our Fulton State Expedited Accusation Calendar. This is a list of misdemeanor cases in which individuals have been recently arrested and booked at the Fulton County Jail, charged with one or more misdemeanor offenses. Upon being booked at the jail, the case was already accused by the prosecutor, which is the Solicitor General's Office of Fulton County. Hence, the case is before the state court, and this would be the defendant's initial appearance before a judicial officer. During the course of these proceedings, which are not only recorded but also live streamed, the defendant will be informed of the case number, the charges brought against him or her, the who is going to be your attorney, as well as your bond amount. If a bond amount has not been previously set, or if you're seeking a modification of the bond that was previously set, we will be looking at the circumstances of the case as well as any prior criminal record history. Please keep in mind that if you are charged with one or more of these offenses, you have a right to remain silent about the facts of the case. Anything that you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you will be one of our attorneys from the Public Defender's Office or from the conflict defense list. Now, if you are an alleged victim or an interested party in the case, if you want to testify, please make sure that your video is on, but that your audio is muted. All right. So let's see. Courtroom 1, good afternoon. Who are we addressing first?
Yes, Judge number 1, position 1, Mr. Earl.
All right, thank you. This is State versus Male Earl or Malay Earl. I'm not sure how to pronounce the first name. Case number is 23 CR 00009Y. Mr. Earl has been accused of battery, domestic violence from September 3rd, 2022. Mr. Earl, you've been advised of your right to remain silent, and your attorney is going to be Miss Miss St. Flex. Are you representing Mr. Earl?
No, Your Honor, that's Mrs. Wright client.
Anna Wright? Miss Anna Wright?
Yes, Your Honor.
Okay. As soon as are you the public defense attorney for Mr. Earl?
Yes, Your Honor.
All right. If you could start your video, please, I'd appreciate it. Thank you. There you are. Perfect. Thank you. All right. Good afternoon. Okay.
Good afternoon.
So Miss Anna Wright is representing Mr. Earl, and Miss Roberts, good afternoon.
Good afternoon.
What is Mr. Earl's prize, please?
He has one prior arrest from 2019 for driving without a valid license, and that was a no-low plea.
All right. Thank you. Prosecutor Ms. Duncan, good afternoon.
Good afternoon, Judge Law. This incident occurred on September 3rd, 2022 at 3181 Donald Lee Hollowell Parkway Northwest. The defendant in this case did repeatedly grab his wife, Miss Nakia Moore or Earl, several times by the arms, causing visible bruising that the officers were able to notate. In this case, we do have concern about the risk of reoffense and possible intimidation of this witness, given that they are married. And we do have some concerns about the risk of reoffense because they do live together. And with our victim advocate speaking to this victim, she did state to us that this is not the first time that this has happened, and that he has been, in fact, terrorizing her since this new year began, and that she's called the police on him several times. But in the last time he was not he was only arrested on this particular warrant. And when he was arrested, the defendant did have his mother call this victim on three-way to try to persuade her to drop the charges at that time. She did file for a TPO previously, but they were unable to serve the defendant. She stated to us that she wants no contact with him. They have, the incident location is not their address.
Yeah, I'm familiar with the warrant. I'm just curious. So they have, well, let me speak to, let's see if the alleged victim wants to say anything.
Yes, Your
in
Honor, and I
terms of
wasn't,
content.
I'm sorry, not to interrupt. I wasn't speaking to the warrant. I was speaking to what she told our victim advocate this morning.
Oh, okay, go ahead.
And she stated that they live at a different address from the incident location and that she wants a stay away from the residence and that she had already packed up his belongings and that she would like for him to be able to retrieve them with law enforcement present. Given that, the state's recommendation is a $3,500 surety, no further contact with the victim, stay away from their home address. It's 3000 Cumberland Club Drive, Unit 3903 in Atlanta. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. And Ms. Earl is on the line.
All right. Ms. Earl, I do see you on the Zoom. If you are satisfied with what Ms. Duncan has reported to the court, you have no obligation to say anything else. Unless you do want to say something, then I'll have to place you under oath.
I agree with everything that she says. And as far as, am I allowed to give a recommendation?
Lift your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
What would you like to tell me?
I'm not sure if she mentioned the type of bond. I'm not really knowledgeable about the type of bonds, but the signature bond is what I would recommend, along with the no contact and for him to get his things as well as leave the spare key.
All right, thank you.
Thank you.
It's right.
Yes, Your Honor. I've spoken to Mr. Earl about this. He is in total agreement about the no contact situation. This happened back in September. He had no idea that there was any kind of warrant out for him. He and Mrs. Earl moved into a new apartment in the new year. He wouldn't have done so had he known that there was a warrant out that she had taken out for him. We ask for a signature bond in this case. Mr. Earl has been working for 6 years as a service technician for Allen Dodds, which is, I believe it's a like a gasoline company that services gas tanks around Atlanta. They don't have any children together. Again, Your Honor, we would just ask for a signature bond and for Mr. Earl to be able to go back to the location with a sheriff's deputy to pick up his things.
All right, bond is set at $5,000. It is a signature bond through pretrial services. He is to have no further contact with Nakia Earl. He's to stay away from 3000 Cumberland Club Drive. Is this an apartment complex?
Yes.
Okay, he's to stay away from the entire apartment complex, including the leasing offices and their common grounds. He is not to return to that location. If he has any personal belongings, a third party may go and retrieve his personal belongings. Ms. Earl, can you identify anyone who can pick up the belongings for Mr. Earl?
Excuse me, Your Honor. Is he able to go back with a sheriff's deputy to pick up?
No, I'm not going to permit that.
Okay.
I need a third party identified who can pick it up. Would it be his mother or his a friend, a mutual friend? Ms. Earl?
He has a brother that lives close by that could help him
What's the
retrieve
brother's name?
his mother.
What's
Adon.
the- Spell it.
ADHAN.
ADHAN. Same last name?
Canario is his last name. CANARIO.
CAN.
Yes.
IRO, Canero?
Canario. So CANARIO.
ARIO. Okay. All right. The reason I'm not letting the defendant go to the premises is my concern about just the allegation of prior altercations, or I'm not certain, but given the circumstances, Mr. Earl is not allowed to return to the entire apartment complex, including the leasing office and common grounds. This individual by the name of Adan Carrerio may go to the apartment complex one time only with the police officer to retrieve Mr. Marley Earl's belongings, as Mrs. Earl has already nicely packed them away, so it's just literally a one-time pickup. Mr. Marley Earl, you are to stay away from Miss Nakia Earl at least 200 yards away. You're not to communicate with her through in person, through a third party, through a telephone, through a computer, or through social media. If anyone engages with Miss Nakia Earl on your behalf, like for example, your mother reaches out to her, that would be considered a violation of the no further contact order, and you could end up being back in jail and losing your $5,000 signature bond. No illegal drugs, no alcohol, and you're not allowed to possess any weapons or any firearms. You're within 30 days of being released from the Fulton County Jail, you are to update us with your new mailing address, phone number, and email, and we will send you notice of your next court date. Thank you.
And respectfully,
I'm sorry. He is to attend and complete a one-day anger awareness program with the Fulton County Pretrial Services and report to pretrial every month. Yes, Ms. Duncan?
respectfully, the state would just like to place on the record its objection to the signature bond in the battery family violence case.
Noted. Thank you. Thank you, Ms. Earl. You're free to go. Next case, please.
Position 2, Mr. Gordon.
This is Detrus Javonian Gordon, case number 23 CR 0000101H. Mr. Gordon has been accused of 3 counts of reckless conduct involving a firearm from a June 2nd, 2022 incident. Mr. Gordon, you've been advised of your right to remain silent, and your attorney is Ms. Wright. Any priors, Ms. Roberts?
He has 6 prior arrests. The last cycle is from January 5th of this year out of Clayton County for a probation violation. I'm not showing what the probation is for. It does list misdemeanors. Has
Is it
another
from Clayton County?
Yes.
Okay.
He has another probation violation arrest from December of 2022 in Sandy Springs. A third probation violation arrest from September of 2016 out of Clayton County. He has a driving while license suspended or revoked no Lowe from 2016, a DUI conviction from 2016, and nothing further.
Thank you. Ms. Duncan?
In addition, Your Honor, there was a reckless conduct arrest in 2016 that was eventually null-prossed, I believe, as a part of a plea. This incident happened over several locations with this defendant. There was an argument between one of the victims, who is the mother of his child, Miss Andrea Pless, about her not getting gas for the car. And when the car ran out of gas, the defendant proceeded to argue with Miss Pless about him not wanting to be on earth anymore. And then he pulled out a firearm and began waving it around in the car. A struggle ensued for the firearm, and Ms. Pless was able to take that from him and actually throw it down a storm drain. The defendant got out of the car and went down into the storm drain to retrieve the firearm, and at some point discharged that firearm. Officers found spent shell casings near the vehicle, Your Honor. Further, they were going to visit his friend, one of the other victims in this case, Mr. Trivell Butler. When he went into Mr. Butler's home, he was stating the same sort of suicidal sentiments to Mr. Butler, and he in fact did fire that firearm again inside of that apartment. Officers notated there was a bullet hole in one of the doors that led up to the roof of another apartment. Officers did check. They weren't able to find the projectile for that firearm, but they did check on the other people in the other apartment, and they were okay. What is most concerning, Your Honor, above all, in addition to all the other circumstances, is that when this defendant fired that firearm inside of the location, there was a 7-year-old child in close proximity. that Mr. Butler was watching. That is the other victim with the initials PM, and he fled that location. Officers were, they had to employ drones and negotiation tactics to finally take this defendant into custody, Your Honor. So we do have some concerns, and given the nature of the statements that he was making, the state is going to be requesting a $21,000 surety. That's $7,000 surety per count for the reckless conduct for each victim. We'd ask for no further contact with any of the victims involved in this case, and there's a child involved between him and Ms. Pless. We'd ask for a third-party contact, stay away from Mr. Butler's location. In any of the victims' locations, we just have Mr. Butler's location as it was the incident location. No alcohol, drugs, weapons, or firearms specifically. No further violations of Georgia law, and an MHET. For the record, Mr. Butler's location and the incident location was 415 Morgan Falls Road, which is the Deer apartment homes. However, this incident occurred in several areas near that because he did flee from officers upon firing that firearm. Nothing further from the state.
Thank you. Ms. Wright?
Yes, Your Honor. Mr. Gordon has lived in Georgia most of his life. He does have 2 children. He does work for the Cheesecake Factory. He's worked for them for over 2 years as a server. I understand that there are significant mental health tones in this case. However, I don't think that means that we need to give him such a high bond, like $7,000 per reckless conduct. I think that giving this person the help that he needs is significantly more appropriate. I would ask that Your Honor give him $1,000 for each reckless count and allow him to get mental health treatment. He understands that he needs to stay away. We are in agreement with the other bond conditions, but keeping him in jail isn't going to allow for him to get the help that he needs.
All right. Bond is set at $2,000 on each count. The total bond is $6,000. It is a surety bond. The next court date is January 19. No further contact with, I think it was Andrea Pless, is that correct?
Yes.
And no further contact with Tridell Butler. Does the location of his place of employment, Cheesecake Factory, is that the one near Perimeter Mall? I don't know if that's in the city of Sandy Springs.
Yeah, it's in Perimeter Mall, Your Honor.
Okay, is that in the city of Sandy Springs or Atlanta?
I'm not sure.
Okay. I'm just going to require him to stay away from Miss Pless and Mr. Butler, which includes staying away from their place of employment, where they live, wherever they happen to be. He cannot communicate with them via in person or through a third party phone, cell phone, social media, so forth. Any violations of a no further contact will result in him being arrested with no bond being set. He is also to relinquish and not be in possession of any firearms. He cannot have a firearm on his person, in his home, in any vehicle he occupies, or anywhere near him. His next court date will be January 19. Thank you.
Thank you, Your Honor.
Does that include no further contact with the minor that was present in the home when he shot the firearm?
I don't know who that is, the warrant, so I'm just going to make sure that whoever's responsible for the minor, make sure that he stays away. Does he have any connection to the minor? Is he a relative or a parent?
It was someone that Mr. Butler had at his home that he was watching.
Well, I'm sure Mr. Butler will make sure that the minor is well secured away from Mr. Gordon. Thank you.
Your Honor, he has, just to clear it up, he's not going to go after the 7-year-old or anything like that. He's
That's
happy to stay
good to know.
away.
Thank you.
Position 3, Mr. Hanson.
Okay. This is State versus D'Angelo Hanson, case number 23 CR 000-102Y. Mr. Hanson has been accused of theft by taking from a BP gas station back in August 12, 2022. Mr. Hanson, you've been advised of your right to remain silent. Your attorney at the present time is Ms. Wright. You are also being informed that there is presently a $2,500 cash bond that has been issued by Judge Fred Edie in your open case, 22 CR 680Y. Ms. Roberts, anything else besides the other open case?
He may have another open case out of Douglas County from January 3rd of this year for a felony willful obstruction of a law enforcement officer. And then he has a conviction from 2020. It was a hit and run, but it was amended to a non-fingerprintable offense out of Knox County.
Thank you. Ms. Duncan, I'm familiar with the warrant. I understand that this is an allegation of theft from an employer. What's the state's recommendation for bond?
Yes, the state's recommendation for taking that $1,000 from his employer is that the $2,500 surety bond that's preset on this case remains. As Your Honor stated before this court, this defendant has failed to appear. There is an open case where he does have a cash bond. So the state has some concern that this defendant is a flight risk, given that he has not shown up for previous court dates. So we have concern about his response to the legal process, as well as the risk of reoffending in this incident, Your Honor. That open case ending in 680Y it began in May of last year and has continued to run in terms of FTA. So he's continuing to rack up new charges while out on bond. So we believe that that $2,500 surety in this case is more than reasonable, given that he's taking money from employers and not coming to court. We'd also ask that he stay away from that BP gas station located at 9165 Roosevelt Highway in Palmetto, and have no alcohol, drugs, or weapons, no further violations of Georgia law, and to take a theft class. Nothing
Thank
further.
you. Ms. Wright?
Yes, Your Honor. I'd like to address the issue with the failures to appear. Mr. Hanson is 19 years old. He has been on his own since he was 15 and he was kicked out of his home. He's been couch surfing ever since. It's not that he is running from the law, it's that the address that the courts had for him are an address that he's not welcome to return to. He is a new father. He just had a baby in December. When I talked to him about the theft by taking, he had no idea what that was about. I let him know that our social workers can help him get housing, get himself on his feet, get a job. He's desperate for help, desperate to get his life in order. For that reason, Your Honor, I am asking for a signature bond. Giving him any kind of bond that he would have to pay would mean that he would stay in jail until his case would be resolved.
All right. So he currently does not have a fixed address. Is that what you're telling me?
He does currently live with someone, their name is Trinity Lucas, and I do have an address that I can give the court.
Okay. If you'd like to convey that address to our litigation manager, Mr. Michael Jordan.
I'm happy to send him an email.
Okay, you can send email or chat, whichever you prefer.
Happy to do that right now, Your Honor.
All right. With regards to the bond, it's going to be $1,500. It's going to be a surety bond. His next court date is January 19th. He should stay away from the BP gas station at 9165 Roosevelt Highway in Palmetto, Georgia. And unfortunately, he's got a bench warrant that's been issued by Judge Edie that is not subject to modification at the present time. Both cases are going to be reset to the SAP calendar on January 19th. 2023, and I'm not certain if he's got a hold as well out of Douglas County. We've just been informed. I mean, I just was apprised of a probation violation matter with regards to a felony matter in Douglas County. So even if he makes bond, he may have to be transported to Douglas County to address that other open case.
I understand, Your Honor. Thank you.
Thank you. Yes, Mr. D'Angelo, you have a right to remain silent. I would not recommend that you speak to anything unless you have something to add about the Douglas County matter.
Yeah, the Douglas County matter, I was pulled over and they said I had a warrant for my arrest, and basically, I just bonded out from Douglas County for that charge.
All right.
With the me missing my K court, I really did not know that I had court. I just didn't know.
Understood. Unfortunately, as you are the defendant charged with the crime, you are responsible for making sure that the court has your current contact information. And the court can only send notice to whatever contact information you provide.
The 1,500 surety bond, that just by itself, and then I have to pay the 5,000 cash bond.
You have to make the $1,500 surety bond, and you have to put up a $2,500 cash bond.
All right, thank you.
Thank you.
Thank you, Your Honor.
Position 4, Mr. James.
This is State versus Dion James, accused of battery on December 11th, 2022. Okay, Mr. James, you've been advised of your right to remain silent, and your attorney is Ms. Wright. Your accusation number for this case is 23 CR 000-103G. Ms. Duncan, are you aware if the co-defendant, the alleged co-defendant, is also arrested, or is it just Mr. Dion James right now?
I'm not aware. From what I know right now, it's just Mr. Dion Jones.
Okay, thank you. All right, Mr. Roberts, any priors on Mr. Dion James?
I'm showing one prior arrest from Fairburn from November of 2022 for entering auto, purchase, possession, manufacture, distribution, or sale of marijuana. And that case appears to be open. There's no disposition listed.
And you said that was in Fairburn. Do you know if it's an open CP case with Fulton County?
I looked in Odyssey. I didn't see one.
Okay, thank you. Ms. Duncan, I'm familiar with the terms of the warrant in terms of Antoine Hollins and so forth. What's the state's recommendation for bond?
And Your Honor, that case is in fact open. It's 22 CP 213798.
Okay,
What I saw this morning. The state's recommendation for bond in this case is a $3,000 surety. No further contact with the victim in this case. Mr. Hollins to stay away from the incident location, which is a laundromat, and wherever the victim in this case resides. 1 day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Your Honor, in this case, we do have some concerns about the risk of reoffending given the relationship between the parties. The defendant is the son of this victim's ex-girlfriend, according to the
warrant, yeah.
Warrant, yes. And then we have some concerns about intimidation here because the victim in this case made initial statements to the officers about what happened when they notated his visible injuries. And when we spoke to him this morning, he did recant that statement about the identification. However, he kept the other details the same. So we do have some concerns about intimidation given the relationship between the parties, and given his open case, Your Honor, there's that risk of offense. So given the nature of the injuries to the victim, we request that 3,000 surety with the other conditions as stated on record. Nothing further.
And he's what, 17?
Yes.
Okay.
And
And-
Judge Law,
Yeah,
I'm sorry. I just looked up that case number. It's up under a different booking, and I noticed he's on pretrial, so we're going to surrender that bond.
and what's the amount of that pretrial bond?
It was a UJR, so there's no amount.
Okay, there's no, okay, thank you.
You're welcome.
If y'all are coming off the UJR, that means then he has no bond in that case at present. Would that be correct?
It will be no bond
It would
because
be
it's
no
going to
bond
be
then.
the sale of marijuana was a UJR. The other one was a $5,000 good bond.
It was a $5,000.
Good bond for the
Good
interim
bond.
auto, and then
I
the sale of
see.
marijuana was pretrial.
I see. Okay. All right, Ms. Wright.
I'm sorry, Your Honor. I just want to make sure that everything is in order.
The open felony case 22 CP 213798. What I've just been informed is that he had a UJR, a judicial release bond on the marijuana charge, monitored by pretrial. Due to this new arrest, they're coming off that bond, but there's no amount set. So I'm uncertain whether he's in a no bond status for that marijuana charge. With
Okay.
regards to the other charge, entering an auto, he has a $5,000 surety bond, which he made at the time of his release. So, but now we're talking about this new case.
Right. So, Your Honor, Mr. James denies that he was there at all. He is still in high school. He is on his way to graduate. He also has a job with Chick-fil-A, which he does after school. There is animosity between his mom and the complaining witness, but it doesn't have anything to do with him. He's 17 years old. Whatever kind of bond, Your Honor, we would ask that it be a signature bond. He just can't, he would never be able to make it, especially with the bond being revoked on his other cases. We just ask that you take his age and his ability to make decisions for himself into consideration for a bond. As far as the stay away, I'm not sure. I would object to just a general stay away from wherever this person resides. I would ask that the state give us an address so that my client knows exactly where he's able to stay away from.
Oh, the laundromat?
Yeah, we're
I thought that
asking,
was an address.
No, I think did the state ask for stay away from wherever the victim lives?
Yeah, wherever he happens to be, whether it's in his home, employment, he has to keep a 200
To stay
yard
away
buffer.
from, right,
Yeah,
so stay away from
200
the
yard buffer,
person.
right.
Okay.
Mhm. But, okay, anything else, Ms. Wright?
Not right now, Your Honor.
All right. With regards to Mr. Dion James, the bond is set at 7,500. It's a signature bond through pretrial services. I need his mother, Denisa James, Denisa James, to co-sign the bond. She has to come down to the pretrial services and bring a government issue ID as well as a utility statement with regards to where she and Mr. Dion James lives. The address on the statement must match the address on her ID. So that's very important. And she can co-sign for the bond. Mr. Dion James has stayed 200 yards away from Antoine Hollins. He's not to communicate with Mr. Hollins in any way, form, or manner. And it would be a good thing to stay away from the laundromat as well. I honestly don't remember the address, but
it's in the it's in the report, Your Honor. I remember seeing it.
2216 Godby Road.
okay, in Atlanta, Georgia. All right. Furthermore, Mr. Dion James is subject to a 24/7 curfew. He can only step out of the home for school, for medical attention, to attend court or speak to his attorney, for work, and for church. Any other reason that he's outside of the home wandering around would be a tantamount to a violation of this signature bond. He now has an open felony case and an open state court case, and he's only 17 years old, which is not a great start. So hopefully, if he stays home, maybe we can curb the addition of any future cases. All right. So I understand that we've not had an arrest in the co-defendant, correct?
That's correct, Your Honor.
All right. So we'll take that up when that happens. Okay, thank you. Next,
Judge Law,
yes.
would you not want me to surrender the bond since you're putting him back on pretrial?
You know what? I'm going to reinstate that signature bond on the UJR, please.
And the state would just mark our
Objection
objections
noted.
back.
Yes,
Oh,
objection
you're
noted.
reinstating on the signature bond, but there is a signature. Was there a second bond for 5,000?
That's a surety bond, and that's not forfeited from the arrest. He made that bond.
Okay.
And also the bond hasn't been surrendered yet, so his bond will still stand.
Okay, we'll keep it there, but he'll need to make sure that he reports to pretrial and, well, one more arrest, and then, well, someone has to come up with $7,500 to. Is it possible? It's a CP case, so I don't have jurisdiction to modify that bond.
You're talking about the signature bond?
Yeah.
It's still
The
a
UJR.
signature bond. The bond hasn't been surrendered.
Okay, so let's
Qu-
leave it as it is then. Thank you.
But he currently does have an FTA letter sent out because he hasn't been reporting. So he might have a bench warrant soon.
So we would just ask that the court will allow the Superior Court or
Yeah.
the magistrate to rule on that matter.
Yeah, all I'm doing is reinstating the UJR because he's still going to be reporting pretrial, but he has other fish to fry in Douglas County, so.
And just for the record, I do believe these offenses occurred close in time, so. we
Oh,
can-
I agree. I agree. Okay, moving on. Who do we have in courtroom one? Is that Mr. Lightsy?
Mal.
All right. This is Carlos Maurice Lightsy, accused of battery, domestic violence from January 6, 2023. Mr. Lightsy's case number is 23 CR 001, 000-104H. Mr. Lightsy, okay, yes, I'm familiar with his other new case in which he had just been released on January 5th, 2023. What's your bond recommendation? I'm going to dispense with the pretrial report. I'm familiar with Mr. Lightsy's criminal history record. Ms. Duncan, what's the bond recommendation?
State's recommendation in this case is 5,000 surety, no further contact with the victim in this case. Third party child contact if they have children together. Stay away from the victim.
Latasha Robinson, she is on the Zoom, I believe. I thought I saw that in the chat, but
Yes.
oh, there she is. Okay. All right. You'll need to start your video if you'd like to say anything. Okay. Anything else, Ms. Duncan?
1 day anger awareness, no alcohol, drugs, or weapons, and no further violations of Georgia law.
Oh, thank you. Ms. Robinson, if you wanted to contribute to this hearing, I'll need to place you under oath. Would you like to say something?
Yes.
All right. Please raise your right hand. The other right hand.
I'm sorry.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. What would you like to say?
I know you said something about no contact, but we actually live together, and not when we're in the process of living together. I'm going through an agency named Annie's, and they're in the process of getting us a place to stay. But I was going to advise that I don't know if he wants to continue the relationship, but I was trying to see if both of us could take an anger management awareness class and a domestic violence class together to work on our relationship.
All right, that's something that is very, very personal. And I'm afraid my court is not equipped to handle personal matchmaking matters. But right now I can only consider
the argument was about somebody came and borrowed some of his stuff, and I didn't know he didn't say they couldn't borrow it. So it just escalated from there.
All right. Thank you, Ms. Robinson. Ms. Wright, do you have anything else to add?
Your Honor, the bond is currently set at 2,500 surety bond. We would ask that it would not be raised from that. I understand that Mr. Lightsy has a history, but clearly in this specific instance, Ms. Robinson is not afraid of Mr. Lightsy. She doesn't want a no contact order. We would ask for a 5,000 signature bond on this case. And if they want to, take steps to improve their relationship, that's certainly encouraged, but we wouldn't ask that it be court mandated.
Please mute Ms. Latasha Robinson. Thank you. Anything else, Ms. Wright?
No, Your Honor.
Bond shall remain at $2,500. It is a surety bond. No further contact with Latasha Robinson. He's to stay 200 yards away from Ms. Robinson, not communicate with her in any way, form, or manner. If Ms. Robinson initiates contact with Mr. Lightsy, whether it's through a phone, through a third party, that could risk Mr. Lightsy being placed in a no bond status. He's to also stay away from the incident location. And actually, quite frankly, I did not write that down. So Ms. Duncan, if you have the incident location.
What I have is 259 Richardson Street Southwest.
Okay. Mr. Lightsy, you're not to consume any alcohol, no drugs, and no firearms. This bond amount is not a reflection on Ms. Robinson or anything with her desire to reunite with Mr. Lightsy. This bond is simply a reflection of Mr. Lightsy's likelihood to reoffend. He was just released from jail on January 5th, and this incident occurred on January 6th, within 24 hours. So the court is very, very concerned with Mr. Lightsy's ability to not reoffend. Thank you.
Thank you, Your Honor.
Next court date is January 19th.
Next, we have position 6, Mr. Lowe.
State versus Blue, BLU Love, case number 23 CR 000105C. Mr. Love has been cited with three traffic matters from July 15, 2022. Failure to yield the right-of-way, hit and run, failure of the driver to remain at the scene of the accident, and driving with a license suspended or revoked. The court is also aware that Mr. Love presently has been booked into the jail on an open felony matter as well. Mr. Love, you have been advised of your right to remain silent, and your attorney is Ms. Saintflex. All right. Ms. Roberts, other than the open felony matter, are there any other issues on Mr. Love's criminal record, if any?
I believe the wrong GCIC was printed. I'm
Hi,
trying to
Ms.
verify.
Roberts. Hi.
Hi.
Hi, Your Honor. I have it if you would like me to proceed with the criminal history.
Would that be all right, Ms. Roberts?
Say that one more time. I didn't even hear him.
I have the
Mr.
history if you don't have it.
Thank you.
Okay, so I have a 2017 conviction of battery, felony violence, felony fleeing, and a hit and run that was a first offender plea. However, just to kind of fast forward to 2021, I do have a probation violation in connection to that matter. It just says terms and conditions were altered as a result of that probation violation. In addition, I have a 2020 conviction out of Gwinnett, which was a driving without a valid license, and additionally a hit and run. I know you're aware of the facts of this case, Your Honor, but I think that it's important to know that the warrant spoke to the fact that the defendant was already out on a driving permit due to him being a habitual violator. The vehicle that he was driving was on fire. Johns Creek Fire Department and PD had to respond to put out the fire. The victim of this case, he did have visible injuries from the airbags. Right now, I believe there is a $1,000 surety bond on each count. The state is asking that the court grant a $2,000 surety bond on each count for in total a $6,000 surety bond. He does have an extensive history with driving infractions. The warrant speaks to that. And I think it's important to know that the defendant's birthday is 1998. So he's approximately, 24, 25 years old. And he has a long laundry list of driving infractions. So we are asking for a $2,000 surety bond on each count, $6,000 in total, and obviously no driving as he does not have a valid license.
All right, thank you. Ms. Saintflex?
Yes, Your Honor, as stated, it's my understanding that Mr. Love has no bond currently on his felony charges that he was booked in.
That would be correct.
That's what's on the sheet that I have. So based on him currently having no bond, and that was just set yesterday, there's going to be a dramatic amount of time between now and the next time he's able to have his bond heard again. I think he said that February the 14th was his possible next court date in felony court, but that hasn't been completely confirmed by his attorney. So we're asking that if the court doesn't lower the bond to a $500 surety bond for each charge for him to be able to afford that bond, as well as whatever felony bond is posted, that the bond remains the same. He has lived in Georgia for 15 years. Before that, he was living out of state, but he came to Georgia when he was 9 years old, and he's been here since. It's my understanding he has his mother, sister, grandmother who lives here. The address that I have is for his grandmother. I think there may be or may not be a hold in another county. And so that would also prevent him from being released straight back on the streets as well. He does have joint custody of his children. Both of them are daughters. One is 1 year old and the other is 3 years old. So we're just asking the court, based on his current circumstance financially, of about to start a job and up on the roof in Alpharetta, based on my conversation with him, but not starting one. He's not going to be able to afford much of a bond. So we're asking the court to reduce the bond on the charges or leave the bond the same.
Okay.
And Your Honor, briefly, I'd just like to say that his other case is not something that should be weighed, the fact that he has a no bond on a felony matter. And I think it's also important to know that before he left the scene, he walked over to the victim and told the victim that he was thirsty and he had to piss as he walked off and left the victim.
Yes, I read the warrant. Thank you. Okay.
I know, just for the record. Thank you.
Failure to yield right of way, the bond is set at 1,500. The hit and run is 3,500. And the driving while license suspended or revoked, this is at least a second offense that I'm aware of. The bond is set at 2,000. Total bond is set at 7,000 surety bond. No further contact with the alleged occupant of the other vehicle. I don't know what that person's name is. I honestly didn't remember. If you have it, Mr. Walker, that'd be
I
great.
could put in the chat.
Okay. And Mr. Love is not permitted to drive at all unless he has a valid driver's license, adequate insurance, and proper registration for the vehicle that he operates. And let me see the chat.
I haven't clicked there yet, so it might take me a second, but I'll get
All right.
it.
If you give that information, please forward that to Mr. Michael Jordan so he can put that in the bond order.
Yes, Your Honor. Thank you.
All right. And next court date for this particular misdemeanor case is January 19th. Thank you. Next position I have is Billy Lowe, L-O-W-E. Would that be correct, Deputy?
Yes, ma'am.
Thank you. Mr. Lowe's case is 23 CR 00097C. Accused of criminal trespass at a Chevron Food Mart on January 6, 2023. Mr. Lowe, you've been advised of your right to remain silent, and your attorney is Miss Anna Wright. Any priors, Miss Roberts?
He has 48 cycles. His last arrest was December 18th of 2022 for possession and use of drug-related objects.
Oh, that's good. Thank you.
Okay.
Mr. Walker, what's your bond recommendation?
So I believe he has a bond in place already that was assigned with the warrant, which is a $600 surety. We'll just ask for that to remain in place along with a stay away from the incident location, which is the Chevron Food Mart located at 970 Spring Street. He was asked to leave and he refused.
Ms. Wright, any objection to a $500 surety bond?
Your Honor, we would ask that it be a signature bond. He's a homeless person who needs help.
Understood, but it's tough with the significant cycle. Bond is set at 500. It's a surety bond. Next court date is January 19th, and stay away from the Chevron at 970 Spring Street, Atlanta, Georgia. Thank you.
Thank you, Your Honor.
Position 8, Mr. Reyes.
State versus Martin Reyes, 23 CR 000098F. Mr. Reyes has been accused of criminal trespass at the Ashley Scholar Landing Apartments on January 6, 2023. Mr. Reyes, your case, you have been advised of your right to remain silent, and your attorney is Ms. St. Flex. And how many cycles on his record, Ms. Roberts, and his last one?
Five cycles, but 6 including this arrest. His last arrest was from October of 2022, and he has an open case from that case, 22 CP 213473 for possession of marijuana and carrying a weapon within school safety zone. He has an FTA also from 2022.
Thank you. Mr. Walker?
Yes, Your Honor. The state will be requesting a $500 surety bond along with a stay away from 701 Atlanta Student Movement Boulevard. As you're aware, this is student housing. This defendant has been given a criminal trespass notice prior to this incident. There's been several incidents that occurred prior to yesterday's incident. So we are asking for that $500 surety along with a stay away from the incident location. And obviously, with it being student housing, we do have a concern for the student safety.
All right. Ms. St. Flex, have you had a chance to read the warrant?
Yes, I have, Your Honor.
Any objection to a $500 surety under some circumstances?
Yes, Your Honor. I would ask for a signature bond based on the circumstances. He's informed me that he actually was living with someone who was in that building. One of the people who was in the rooms upstairs that he stated in the warrant that he stayed at was a friend, but he informed me that he didn't want to go and stay in the house sometimes, so he would just stay in the lobby. And so we don't believe that his intent was to criminal trespass on the property, although I have talked to him about not being able to return to that location. He is a student at Clark Atlanta, and he is currently working as a barber on the side when he is not in his classes. So we would just ask for a signature bond so he can return back to school. If the court is not inclined to give a signature bond, we would ask for $1,000 surety, $1,000 surety bond, because for 500, 600, sometimes it's tougher for them to be released with the bonding company with those bonds. So we would just ask for $1,000.
And it's important to
$1,000.
know, Your Honor, that he was previously criminally trespassed from this location before. As far as they know, he is not a resident nor a student. And if he is a barber, a $500 surety bond, which is $50, that's one haircut. So we would ask that the $500 surety is granted.
But the folks, bond is set at $1,000 surety bond. Next court date is January 19th, 2023. And January 19th, if we get the identity of this particular person who gave safe haven to Mr. Reyes on that time of vacation, apartment number, and if he shows up and testifies, I'm sure we can revisit his bond amount. And so his next court date is January 19th. And it's nice to know how much Mr. Walker pays for his haircuts as well. So let's move on. Thank you.
Position 10, Mr. Wyatt.
Mr. Caesar Wyatt is charged with simple battery domestic violence from December 13, 2022. Mr. Wyatt, case number is 23 CR 0001008. Mr. Wyatt, you've been advised of your right to remain silent, and your attorney is Ms. St. Flex. Ms. Roberts, any priors, please?
He has 10 cycles. Last arrest was for FTA out of Cobb County from May of 2022. He appears to be on probation out of Cobb for criminal damage to property. Disposition was July of 2022, 12 months probation. He has a 2019 conviction for 2 counts of misdemeanor marijuana possession less than an ounce out of Fulton County.
All right. May I just clarify again that this was a Cobb County criminal disposition in July of 2022. Would that be correct?
Yes, correct, Your Honor.
And is that a felony charge?
Yes, Your Honor, 2nd degree criminal damage.
So he's got a felony conviction, and there's an allegation of a firearm from December 13, 2022.
Yes, Your Honor.
Understood.
And then I have another case from 2019, originating out of Dunwoody. That's also a simple battery along with possession of a firearm. I do not have a disposition of that case. However, I do have arrest for a simple battery along with possession of a firearm without a license out of Dunwoody. In this case, law enforcement responded to 993 Mansell Road. They spoke to the victim, Mrs. Simpson. She is on the line. You can't see the spelling of her first name. I will not try to pronounce it. The victim actually did not call the police in this case. They were located in a shopping plaza where one of the employees who worked at that plaza called 911 and gave a statement.
I read the warrant too.
Okay,
I do understand that Ms. Simpson was not the caller.
Right. So with that being said, we're asking for a $2,000 surety bond with no further contact with the victim. He does have a history with firearms. As we know, with domestic violence and firearms, the risk of mortality, it greatly increases. So we are asking for a and no further contact, and a $2,000 surety bond based on his history and the facts of this case, Your Honor.
Understood. Thank you. Ms. St. Flex, would you like to say something, or shall I let Ms. Simpson articulate her position right now?
I would like to summarize Ms. Simpson's position, and if she wants to add to it. I spoke to Ms. Simpson this morning. It's my understanding that she's not in fear of Mr. Wyatt, and that she wants contact. And so I'll just let her add anything additional to that if she pleases.
All right. Ms. Simpson, if you'd like to unmute, please.
Hello, good afternoon.
Good afternoon. Could you please raise your right hand if you'd like to say, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. And what would you like to tell us?
Well, a few of the counts that you have listed, I'm sorry, I didn't catch your name, by the way. Is it Mr. Walker?
It is.
Okay, a few of them are incorrect because some of them have already been dismissed and we've already handled those. When it comes down to the firearm, he's already gotten those firearms back. So that's one. And then two, he actually lives with me. So as far as the no contact goes, I did want to go ahead and not proceed with that because we have children together just as well.
Okay.
And Your
Okay,
Honor,
well, since
very,
the
very
defendant
briefly,
has
at the,
firearms, the state will be modifying its request and ask for a condition of no firearms, as this is an allegation of domestic abuse, Your Honor. Thank you.
Your Honor, very briefly as to the contact part, it is my understanding that he does help pay rent for the home.
Yes.
And that Simpson would not be able to afford to pay the rent, and he also assists with the kids going to and from their daycare and additional needs for the home. He works at Navis Tire Place, and it's my understanding that from his conversation with his assistant manager and manager that he still will have a job temporarily if he leaves the jail soon. So we would just ask for no more, if the court is not inclined to give a signature bond, no more than $1,000 good bond.
Yeah, I understand that the victim wants contact, but I would ask the court keep in mind that this argument was based upon the defendant trying to take the victim's keys. So if the victim didn't want the defendant to have her keys, I think that's indicative of what the order of contact should be.
Bond set at 2,500. It's a surety bond. Next court date is January 19th. No further violent contact with Ms. Simpson. And while he's out on bond, if he makes bond, he would have to make sure that he does not consume any alcohol, no illegal drugs, and he's to surrender all firearms back to the police authorities or remove them from his home, from his person, from he cannot have any firearms in his vehicle or anywhere near him. So I'm not certain on what grounds firearms were surrendered back to Mr. Wyatt, but if he has a felony conviction on his criminal history record, by law, he cannot possess or own any firearms. Otherwise, he would be, well, in trouble again with the law. Thank you.
Okay, that's understood. Thank you.
Next court date for Mr. Wyatt is January 19th. Okay, Miss, I think we've concluded with courtroom 1. We have one case involving a Shanta Robinson.
Judge, I'm sorry to interrupt. Before we conclude with courtroom 1, I just want to clarify about position 2, the reckless conduct cases. What was your
2,000 on each count, 6,000 surety.
were you not inclined to grant the MHET in this instance?
I don't have enough information for the MHET.
Okay, it was my impression that the defense was in agreement that there were some MH issues, and the reason behind these charges was an MH issue. So the state would just again like to reiterate its request for that, since he's supposed to get it on his own. We'd like for that to be a part of the order.
Ms. Wright, if the defense believes that MH evaluation is required and we need to move forward, please go ahead and submit the necessary documents to get an evaluation.
To clarify, Your Honor, I do not think that that's the case. I said that it should not be the reason why a bond should be $7,000 per case.
That's what I thought your position was. So yeah, that's why I'm not issued a MHET. Thank you.
Thank you, Your Honor.
Understood. I just want to make it clear for the record.
Understood. Thank you. All right. Deputy, do we have a Miss Robinson at your location, or are we going somewhere else?
She is a medical reset.
Okay.
Your Honor, at this point, the state's gonna be requesting a mental health evaluation. She's been reset 3 times previously. At one point in time, it was announced that it was due to behavioral health or mental health issues. She's been on the calendar for the majority of this week.
I know she's been reset since the 5th.
Right.
So
one of the announcements was
who's her
behavioral health.
attorney?
I was supposed to be representing her, but I was not able to speak with her this morning. We have not waived her presence. The information that I received was that she was a medical reset. And so I would ask that, you know, any conversations regarding the substantive or what happens would be done with her present.
Okay.
Oh, no, this wasn't in regards to what happened as far as the case. This was what happened this week during court. She's been reset 3 times, and the announcement previously was due to mental health reasons. So at the time that it's been reset 3 times, I think at a certain point we have to call in and do a mental health evaluation.
Right. I'm just going to interject this point. Courtroom 1, we concluded. We're just going to be going over the calendar very soon. So y'all are free to go. Thank you. And with regards to Ms. Robinson, I've only looked up at Odyssey. I'm not certain what is the other than just the medical resets. So I'm going to do a final reset to Monday. And that would be today's the 7th, 8th, 9th. So that will be January 9th, 2023. And Ms. St. Flex, I don't presume to believe that you would be the PD.
I will not, Your Honor. I'll be in
Okay.
trial.
Please
Right,
let
Your Honor, and that's
the,
why this day is requesting a mental health evaluation, because I did
There
inquire
will,
with
our
the
office
Hang
will
on,
be
folks. Hang on,
representing.
folks. Yes, one at a time, one at a time, one at
I
a time.
did inquire with our attorneys who handled this case earlier in the week, and the initial announcement was the PD's office was unable to speak with the defendant due to her mental health. So,
Mr. Walker, I agree. And so I'm going to let the PDs one final opportunity to see if they can reach out to her or make their decision as to whether they want to waive her appearance. Okay.
hopefully, I don't think you can waive the appearance of someone who doesn't have competency, but hopefully the 4th time is the charm.
Well, 4th time is always a charm, isn't it? Okay. And Mr. Walker, yeah, we will address that on Monday. And every time we reset it for MH or medical reasons, it does not trigger a Riverside issue.
I know, but you know,
So-
I do the competency calendar. So when we continue to reset cases, when we can order evaluation.
Understood.
I just don't want to
And
prolong
the
it.
PD's office is also noticed that they have a possible client who is sitting in the jail cell awaiting an initial appearance, or at least to be granted a bond or have something to move on forward if an MH is involved. I
Yes,
can
Your Honor.
only grant something once the PD's office makes an evaluation as well. So
Yes, Your Honor. And we
I
just wanted to
respectfully
inform the
disagree.
court that our clients have been sitting in jail for 100 and 200 and 300
Miss
days.
St. Flex, this is
waiting
not
for
the time to get on.
evaluation.
No, Miss St. Flex. Not a time to get on the soapbox. Let's
No,
focus.
not a
Let's
soapbox.
focus.
Facts, Your Honor.
No, do not interrupt again. Let's focus on the client that we're discussing.
Yes, Your Honor.
All right.
We have nothing further. We're done.
All right, let's go over the calendar, please. Position number 1 is a $5,000 signature bond for the notice. It's through pretrial. Position 2 is a $6,000 surety bond, reset to January 19. Position 3, $1,500 surety, January 19. Position 4, $7,500 signature bond with a co-signer, Ms. Denisa James. Further notice. Should I put that on the January 19th calendar in case mom doesn't show up?
There's no
Yes.
objection from the state.
Yes, Your Honor.
All right. Let's just put that on the January 19th. If he bonds out, then that case will be taken off the calendar. Position 5 is a $2,500 surety bond, January 19th. Position 6, a $7,000 surety bond, reset January 19th. Position 7, 500 surety, January 19th. 8, 500 surety, $1,000 surety, January 19th. Position 9 is a medical reset. This is a final medical reset, subject to the PD's evaluation, to January 9th. And position 10, a Wyatt, is a $2,500 surety bond, reset date January 19th.
Ms. Law,
Yes, Mr. Jordan?
were there any conditions for position
Position what?
8? Position 8?
8.
Reyes?
Okay.
What defendant was that?
Position
Position
8
eight.
is Martin Reyes. He is to stay away from 701 Atlanta Student Movement Boulevard, which is also called the Ashley Scholar Landing Apartments, the entire complex, including the leasing office and the common grounds.
Okay, thank you.
All right. All right, folks, that concludes our calendar. Everyone enjoy the rest of this weekend, and we will see you next week. Take care.
Thank
Thank
you.
you.
Bye, y'all.
Bye-bye.